On March 8, 2004, the Congress enacted the Republic Act No. 9262, also known as the Anti-Violence Against Women and Their Children Act of 2004. RA 9262 is a landmark legislation that defines and criminalizes acts of violence against women and their children perpetrated by women's intimate partners, such as the husband, former husband, or any person who has or had a sexual or dating relationship or with whom the woman has a common child. The petitioner of this case, Jesus Garcia, assails the constitutionality of RA 9262 as being violative of the equal protection and due process clauses. Rosalie Garcia, the wife of Jesus Garcia, described herself as a dutiful and faithful wife, whose life revolved around her husband. On the other hand, Jesus Garcia is dominant, controlling, and demands absolute obedience from his wife and children. Jesus forbade Rosalie to pray and deliberately isolated her from her friends. When she took up law, and even when she was already working, Jesus trivialized her ambitions and prevailed upon her to just stay at home. Things turned for the worse when Jesus took up an affair with the bank manager of the Robinsons Bank, who is the godmother of one of their sons. Jesus admitted to the affair when Rosalie confronted him about it in 2004. Jesus even boasted about his sexual relations with the said bank manager. Jesus told Rosalie, though, that he was just using the woman because of their accounts with the bank. Jesus' infidelity spawned a series of fights that left Rosalie physically and emotionally wounded. In one of their quarrels, Jesus grabbed Rosalie on both arms and shook her with such force that caused bruises and hematoma. At another time, Jesus hit Rosalie forcefully on the lips that caused some bleeding. Jesus sometimes turned his ire on their daughter Joanne, who had seen the text messages he sent to his paramour and whom he blamed for squealing on him. There are multiple issues in the case. First, does the anti-VAUSI law violate the Equal Protection Clause by favoring women over men as victims of violence? Second, does the anti-VAUSI law violate the Due Process Clause of the Constitution? Third, is there an undue delegation of judicial power to barangay officials? As to the first issue, the court ruled in the negative. Equal protection simply requires that all persons or things similarly situated should be treated alike, both as to rights conferred and responsibilities imposed. RA 9262 is based on a valid classification, as shall hereinafter be discussed, and as such did not violate the Equal Protection Clause by favoring women over men as victims of violence and abuse to whom the state extends its protection. RA 9262 rests on substantial distinctions: the unequal power relationship between women and men, the fact that women are more likely than men to be victims of violence, and the widespread gender bias and prejudice against women all make for real differences, justifying the classification under the law. On the other hand, no reliable estimates may be obtained on domestic abuse and violence against men in the Philippines because incidents thereof are relatively low. While there are indeed relatively few cases of violence and abuse perpetrated against men in the Philippines, the same cannot render RA 9262 invalid. The classification is germane to the purpose of the law. The distinction between men and women is germane to the purpose of RA 9262, which is to address violence committed against women and children. The classification is not limited to existing conditions only and apply equally to all members. Moreover, the application of RA 9262 is not limited to the existing conditions when it was promulgated, but to future conditions as well, for as long as the safety and security of women and their children are threatened by violence and abuse. RA 9262 applies equally to all women and children who suffer violence and abuse. There is likewise no merit to the contention that RA 9262 singles out the husband or father as the culprit. Vowsy may likewise be committed against a woman with whom the person has or had a sexual or dating relationship. Clearly, the use of the gender-neutral word person, who has or had a sexual or dating relationship with a woman, encompasses even lesbian relationships. As to the second issue, the court ruled in the negative. The essence of due process is to be found in the reasonable opportunity to be heard and submit any evidence one may have in support of one's defense. It should be recalled that Jesus Garcia filed on April 26, 2006, an opposition to the urgent ex parte motion for renewal of the temporary protection order that was granted only 2 days earlier on April 24, 2006. Likewise, on May 23, 2006, Garcia filed a petition for the modification of the TPO to allow him visitation rights to his children. Still, the trial court in its order, dated September 26, 2006, gave him 5 days within which to show cause why the TPO should not be renewed or extended. Yet, he chose not to file the required comment, arguing that it would just be an exercise in futility, conveniently forgetting that the renewal of the questioned TPO was only for a limited period of 30 days each time, and that he could prevent the continued renewal of said order if he can show sufficient cause therefor. Having failed to do so, Garcia may not now be heard to complain that he was denied due process of law. As to the third issue, the court ruled in the negative. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. On the other hand, executive power is generally defined as the power to enforce and administer the laws. It is the power of carrying the laws into practical operation and enforcing their due observance. The court has held that the mere fact that an officer is required by law to inquire into the existence of certain facts and to apply the law thereto in order to determine what his official conduct shall be, and the fact that these acts may affect private rights, do not constitute an exercise of judicial powers. The preliminary investigation conducted by the prosecutor is, concededly, an executive, not a judicial function. The same holds true with the issuance of a barangay protection order. The court did not even belabor the issue raised by Garcia that since barangay officials and other law enforcement agencies are required to extend assistance to victims of violence and abuse, it would be very unlikely that they would remain objective and impartial, and that the chances of acquittal are nil. As already stated, assistance by barangay officials and other law enforcement agencies is consistent with their duty to enforce the law and to maintain peace and order.